Chairman and Commissioner McElhaney, thank you for your service, and those of your officers. We appreciate what they do every day, including, of course, interdicting heroin, fentanyl, other drugs coming into our country. We're trying to help you on that, by the way. The STOP Act, as you and I have talked about many times, would be a tremendous help to give you the data that you need to interdict these packages that are coming in from overseas, primarily, mostly from China. And as you know, fentanyl is now the #1 killer in my home state, and I believe among the opioids, #1 killer in the country. And so we hope to follow suit with the House very shortly and get you those tools. I've talked to you briefly before the hearing started to warn you about what I was going to talk about, but it's a big issue, but you have a specific role that would really help. And it has to do with these steel tariffs, their impact on our economy, and how we go about ensuring a level playing field. The 232 measures, which are under a national security, really a waiver under our trade law, doesn't require us to show an injury to our industry. It doesn't require us to show any unfair trade. But as you can see, other countries are retaliating aggressively against us as we use this tool. My fear is those trade escalations will continue. It's going to hurt our consumers, but also our exporters and our manufacturers. So what's the problem? Well, the major problem, everybody seems to agree, is overcapacity, steel production in this world. And primarily that's, again, China. About 15 years ago, they had 15% of the global production. Now they have about half the global production. And they do sell their steel at below cost. We've been able to show that and win some trade cases on that. And I think that's good. One of the problems is they try and ship it through other countries. And that's why, working with Senator Wyden and others, we passed this legislation called the Enforce and Protect Act, also known as the Enforce Act, because we recognized the overcapacity problem, wanted to deal with the duty evasion issue and the transshipment issue. And we vested a lot of responsibility in you and your people. I know you got a lot to do with people and drugs and other issues related to commerce, but this one is really important. And frankly, I don't know that we would need to have a 232 case and have all of the potentially negative consequences that come from that if we were doing a better job on transshipment. I know you appreciate its importance. We've had some successes in the wire coat hanger case. For example, the Enforce Act was essential in saving the last manufacturer in the United States. Couldn't have done it without the legislation, without your help. Unfortunately, with all the things that have distracted your people and your lack of hiring and so on, we talked about earlier, the legislation remains underutilized. One reason, I think, is that we don't see as many allegations as we should because we don't have this ability to have administrative protective orders. The International Trade Commission, Department of Commerce, both successfully use these, the APOs, administrative protective orders, to facilitate confidential information sharing with interested parties. And I strongly believe that there's an opportunity to apply that here to the Enforce Act. I've heard from a lot of stakeholders about this. They want this process at CBP because they understand how useful it can be. I know you don't have the legal authority to do it yourself, but I want to hear from you today. Do you believe that creation of an APO process under the Enforce Act would make the process more useful for petitioners and thus increase the number of petitions?
Thank you, Senator, for the question, and to the committee for the authority under the Enforce Act, which we've taken on, implementing an interim final rule within 6 months of the passage of the Trade Facilitation Trade Enforcement Act. We're now up to 20 investigations, 9 completed, $50 million in duty evasion prevention accomplished. We've done foreign site visits in over 18 locations, which has really given us a sense of where there's a fraudulent issue, a fake transshipment, if you will. We're able to actually look at that factory using our international network, our partnership with foreign governments and with HSI.
By the way, your interim rules came out in August of 2016. We're still waiting to the final regulations. So if you could also tell us today when you expect those final regulations to come out, that would be helpful.
Well,
do you have an answer on that?
Actually, I think that depends on the second half of your question, the ongoing lessons learned from these 20 investigations and the incoming allegations under the Enforce Act, the lessons we take from those, and how we want to apply them in a final rule. The administrative protective order process is something that we've looked at and that we're happy to have an ongoing conversation with Congress about. As you noted, we don't have the authority or the resources to implement it today.
Do you think it would be helpful?
I think that the key elements of it, the sharing of additional information with
Confidential
interested
information.
party is very helpful.
Okay.
And whether we can do that through a final rule on our own or whether an APO would materially advance that's worth discussing, absolutely.
But you want to get that confidential information. Another area we can improve the Enforce Act would be to allow petitioners to file allegations when the importer is not known, because that's the case sometimes. They see innovation coming, they're tracking prices, market dynamics. They know it's happening, they're just not sure who's doing it. Again, legal authority aside, do you believe that permitting allegations when an importer is unknown would make the process more useful for petitioners and help increase the number of petitions?
Yes, we agree with that. That's an improvement we'd like to make in the process.
So it sounds like the first one, you'd like to make the change substantively, whether it's through an APO or some other way. And the second one, you believe people ought to be able to file these cases without knowing the importer.
Correct.
Great. Thank you, Mr. Chairman.
Senator